Welcome to the Corruption Files Update. This is your quick hit on the latest filings, breaking news, or bombshell developments in the cases that we follow. No fluff, just the facts that you need right now. Let's dive in. Hi, everyone. Welcome back to Crime in Court with Heather. This is an update in the Corruption Files Richard Allen case. We're going to be talking about Delphi. And so just this week, the defense team for Richard Allen filed their latest in his appeal. So really quick, let's kind of work backwards. So I have not gone over these filings. The first original filing that uh, that his team dropped was in December of 2025, and it was 113 pages. So I will go over it if you guys would like me to. Let me know in the comments. But we're going to be going over, this is like the reply. So basically, let's backtrack. So December 2025, Richard Allen's appellate team files the 113-page brief. Basically, the three major points that they talk about is one, the search warrant was not maybe true or accurate. There were maybe some misleading statements or false statements that were made in order to get that search warrant. So that's their biggest first argument. And they said that the trial court, Judge Gull, should have had a Franks hearing to investigate what was going on with the search warrant and all of those things. Secondly, Richard Allen's confessions, they argue, are not voluntary. They were made while he was under severe mental distress, severe mental health disorders he was having at the time due to solitary confinement. He was essentially gravely disabled, so anything that he said should have been thrown out. Their third and final major argument for their appeal is that the trial court denied him the right to present his complete defense. So she basically, the motion in limine eliminated them from talking about any alternative theories, any people that were involved in the Odin stuff, anything that had to do with the Odinism, the sticks, the runes, all of it. They were very, very limited on what they could bring out. Overall, the defense asked the Court of Appeals to reverse the conviction or, at a minimum, give him a brand new trial. So the state responded in March of this year. A few points that they made was basically it was very, straightforward, whatever. They said that the search warrants were valid and there were no falsehoods or omissions when they were made that would justify a Franks hearing. But yeah, it's like taking the word of a criminal, sometimes the government can do criminal things. So you're taking the word of the government when they've already done some awful things to Richard Allen. And then they also argue that Allen's confessions were voluntary and it doesn't matter what his mental health state was at the time. And then finally, they defend all of the rulings of Judge Gull, of course, saying that there was no harmless errors or anything like that, or that there were no harmful errors, and everything her decisions didn't affect the outcome of the trial, is what they state basically. So they say everything was handled correctly and the conviction should stand. It's very lacking in, substance. So now we are going to read through. This is the defense's response to the state, basically saying, no, we don't believe anything you just said in your 113-page brief. We're just going to say we stand by the conviction, and that's that. So that's basically where we're at now. And let us get to It is not 113 pages. It is 58 pages. And we're starting on page 9 because all of the stuff above is like table of contents and stuff. So we don't need all of that. So we're starting here. The summary of argument: unconstitutional search. The trial court committed reversible error by admitting evidence obtained through an affidavit built on deliberate falsehoods and material omissions. Detective Liggett falsely swore that witness Carbaugh gave an incriminating description in 2017 and that Allen admitted wearing matching clothing. Neither was true. He simultaneously concealed Blair's eyewitness description. So Liggett concealed Betsy Blair's eyewitness descriptions, which excluded Allen and his vehicle, withholding from the issue judge the very evidence ISP had validated in a 2019 press release. So they say it was Allen's car, but Betsy Blair actually, her descriptions and her eyewitness statements made it clear that Richard Allen's car was not there. She saw something totally different. All right, so the pattern is unmistakable. Every fact undermining Liggett's theory was omitted. Every fact supporting his theory, however distorted, was included. So everything that fit Liggett's theory was, of course, included in the search warrant, but there was no exculpatory or any other factors that didn't support Liggett's theory in the warrant, in the papers filing for the warrant. So you strip away the falsehoods and restore the omissions, and probable cause evaporates. Because Allen exhaustively litigated suppression below, his challenge is preserved. Unprecedented confinement. The trial court committed reversible error by admitting confessions the state extracted from a man it broke. Law enforcement interrogation is not required for coercion. Prolonged solitary confinement on a severely mental ill detainee plainly qualifies, especially where law enforcement, upon learning of the inmate's grave disability, doubles down and starts collecting confessions. What? So they learn, oh, we made him delusional. We gave him delirium or something. And, whatever the actual diagnosis was, psychosis with something, I can't remember what. So that is, then when they find that out, that he has this psychosis, they start doubling down and collecting confessions. I did not put the 2 and 2 together just like that, but that is what they did. So the state's attempt to reframe Allen's 13 months of maximum security isolation as routine custody cannot be reconciled with IDOC's own policies, the IPAS litigation, or the unprecedented harshness of Allen's confinement. The state failed to prove beyond a reasonable doubt that Allen's confessions were a product of rational intellect rather than their deliberate indifference to his mental health. Unfair trial. A criminal defendant has a federal and state constitutional right to present a complete defense, and evidentiary rules that exclude critical defense evidence on grounds disconnected from the rules proposed violate that right. Holmes versus South Carolina. The trial court's rulings on 7 categories of defense evidence violated that right. So they're saying 7 of her rulings violated his constitutional right to put on a complete defense. The state's brief argues at length that the evidence against Allen was overwhelming, but the state's case was a paper tiger, and the trial court systemically barred Allen from lighting a match. The jury never saw the sketch that proved Blair did not see Allen. Remember, all the sketches were not allowed. Neither of the sketches were allowed. Right before trial, she ruled on that. The jury never saw the sketch that proved Blair did not see Allen. It never heard the ritual explanation the state itself once pursued, the ritual sacrifice type of thing. It never heard the scientific critique of the unreliable methodology that produced the firearms match. It never heard the evidence implicating two named alternative suspects and law enforcement's failure to investigate them thoroughly. It never heard the audio of Allen's psychotic episodes, the bookend calls, and clinical observations that would have impeached his confessions or the unimpeached phone data that contradicted the state's timeline. Every ruling was reversible error standing alone. Together, they kept Allen from setting the state's case ablaze and denied him a fair trial. Compounding these errors, the state knowingly presented false testimony from Brad Weber about when he arrived home on the day of the murders. Testimony the state's own FBI subject information sheet refuted, and then exploited it in closing as an act only the killer would know. The van. Only the killer would know that that van came down that road, even though it was all over social media. When Allen attempted 6 times to correct the falsity, the state obstructed every attempt. Argument. The trial court committed reversible error by admitting evidence seized from the unconstitutional search and denying a Franks hearing. Allen's exhaustive pretrial litigation preserved the Fourth Amendment issue. The state contends Allen waived his Fourth Amendment challenge by stating no objection when individual exhibits were offered at trial, but the argument fails on 3 independent grounds. First, the purpose of the contemporaneous objection rule was fully satisfied. The overriding purpose of the requirement for a specific and timely objection is to alert the trial court so that it may avoid error or promptly minimize harm. Courts should not apply the rule with unyielding rigidity when this purpose has been met. Allen's attorneys exhaustively litigated the suppression, filing multiple motions supported by more than 130 exhibits. After the court denied the motion to suppress without a hearing, Allen renewed it twice more, which the court again denied. So she's talking about the suppression of the confessions, filing multiple motions. The court denied it without a hearing. Throughout the extensive briefing, Allen repeatedly emphasized Liggett's omission of Blair's description and the falsehood about Carbow. Allen did not idly sit by only to cry foul when the court ultimately renders an adverse decision. There is absolutely no strategy for Allen's attorneys' failure to object to evidence that they so aggressively litigated. For judicial efficiency, the issues should be resolved now rather than on PCR. Second, the recent amendment to Evidence Rule 103B confirms that Allen's challenge is preserved. So basically they're saying because they litigated it all a bunch in pretrial, he already objected to it multiple times, that all this stuff coming in, the sketches, the police sketches, I couldn't think of the words, those police sketches they're talking about, that they're not coming in. So this, I totally lost my train of thought. The police sketches are what they're talking about here. So there is absolutely no strategy for Allen's attorneys' failure to object to evidence that they so aggressively litigated. For judicial efficiency, the issues should be resolved now rather than on PCR. So basically, they're saying even if his attorneys didn't object during the trial, they objected it during the pretrial, so there was no point for them to object when they knew that the judge would have just denied their objection. So that's kind of what the argument was there. Second, the recent amendment to Evidence Rule 103B confirms that Allen's challenge is preserved. Same kind of thing here. The Indiana Supreme Court amended Rule 103B to clarify that once the court rules definitively on the record, either before trial or at trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. So they don't need to renew the objection if they've already objected to it beforehand in pretrial filings and motions and things. So this includes a ruling on a motion in limine. So just because, they objected to the motion in limine being allowed with all this stuff that, Nick McLeland wanted disallowed, they objected to it prior to trial. They don't have to, during trial, object every single time something comes in about that, or, every single time you skirt around the idea of those things. So they don't have to keep objecting. The state urges this court to ignore the amendment because it was not in effect at the time of trial. But because the rule governs what is required on appeal, it should be applied to Allen's pending appeal. At minimum, the amendment reinforces the DRC principle that the contemporaneous objection rule must not be applied with unyielding rigidity. Third, the Franks hearing denial is a pretrial constitutional rule requiring no trial objection to preserve. So you don't even have to object. But this Franks hearing, this is going to, they asked 3 times for Frank's hearing. They renewed their motions multiple times. She just ignored every single one. So they have a real big leg to stand on for this, I think. The trial court did not merely admit evidence, it refused to hold a Frank's hearing, which is Franks versus Delaware. That's the standard they use to try to bring in evidence if you have something that you want before the trial court, before trial happens. So once a ruling was made, no further objection at trial could undo it. The state cited no authority requiring a defendant to object at trial to preserve the denial of a Franks hearing. So I'm assuming maybe in the state's filing they said, well, you didn't object at trial, so obviously you've waived your right to object to it now on appeal, which is totally different. And she's saying all the pretrial stuff where you're objecting to it counts and you don't have to do it during trial. That's basically the gist of that. All right, so Detective Liggett included multiple deliberate falsehoods in the affidavit. The state argues that Liggett's representation of Carbaugh's account that she reported seeing a muddy and bloody man wearing a blue-colored jacket was not a false statement and that any inaccuracy may have been a mistake. This argument also fails. Liggett did not just represent what Carbaugh said, he represented when she said it, swearing that she gave her description in 2017. The temporal representation added a veneer of reliability because a description given close in time to the murders carries obvious weight. So the fact that he's saying he remembers it being in 2017 gives it a lot of weight because it's so close in time to the murders. The state concedes that in 2017, Carbaugh never described the man as bloody or as wearing a blue jacket. She described him as muddy and wearing a tan jacket. So she changed the color of his jacket and she changed muddy to bloody over time. The evolution of Carbaugh's statements made the affidavit more misleading, not less. That Carbaugh's account changed over the years from muddy to muddy and bloody and from tan to blue jacket is precisely the kind of information the issuing judge needed to assess her reliability. So that's why she should have been brought in for a Franks hearing. Police officers seeking a warrant should provide the magistrate, a trial judge with all information at their disposal concerning a source's reliability. Instead, Liggett only included the version of Carbaugh's account that fit his conclusion and falsified when she gave it. It is also implausible that Liggett made an honest mistake. Liggett was the officer who interviewed Carbaugh in 2017, and Liggett also omitted that Blair did not believe she saw the same man Carbaugh did, resulting in a 2019 ISP press release that the man Carbaugh saw was not Bridge Guy. It is no coincidence that the false statement and the omission both bolster Liggett's new conclusion that Blair and Carbaugh both saw Bridge Guy. The Carbaugh falsehood is not the only one in the affidavit. The state does not dispute that Liggett falsely stated in the affidavit, written the same day Allen was interviewed, that Allen admitted wearing a black or blue Carhartt jacket. So he admitted to wearing a black or blue. So her statement went from tan to blue right around that time. In fact, Allen told investigators he did not know what he was wearing that day. Even if Allen did not argue this specific falsehood in his briefing below, the court may consider it in response to the state's appellate argument that Liggett simply forgot. The common thread is plain. Liggett's affidavit forgot every fact that did not fit his theory that Bridge Guy was Allen. So it's just convenient that he forgot every single fact that disproves Allen is Bridge Guy. Convenient, huh? Blair's omitted descriptions were made with reckless disregard for the truth because they directly negated the warrant's core finding that Allen was Bridge Guy. So Betsy Blair, we just read through her another portion of her testimony while the defense brought her up as a witness, and she describes the car that she sees, which is not a Ford, not a black Ford Escort, which I think is what he had, but it's some kind of Comet, old 1950s car that she remembers her dad having as a young girl. And it was definitely not black, she says. So her description and seeing not Alan's car, but somebody else's car at that time really kind of messes up the state's timeline there. So while the state concedes Liggett omitted parts of Blair's identification, excluding Allen or his vehicle, the state argues that Allen failed to show these omissions were made with the requisite intent to mislead or with reckless disregard for the truth. The state is wrong on both law and the facts. The state misreads State versus Allen as holding that intent to mislead cannot be inferred from omissions themselves, but the case rejected the proposition that any omission shows such intent, not that a material omission cannot support that inference. I didn't understand that, so I can't really explain that. Sorry. Settled Indiana law provides that omissions are made with reckless disregard for the truth when an officer withholds a fact in his ken that any reasonable person would have known that this was the kind of thing the judge would wish to know. So basically, if the judge would have wanted to know that there was another witness who did not see Allen's car at that time, but saw an old 1950s, whatever, she might want to know that, or he might want to know that before making a decision on granting a warrant, a search warrant for someone. Blair's omitted descriptions were exactly the kind of fact that he omitted. Blair's descriptions directly undermine the affidavit's central conclusion that Allen is the individual on the bridge. Liggett swore under oath that he was able to corroborate information that Allen was at the trails at the same time as Libby and Abby were. And the individual in that picture on Libby's phone matches the description of Richard Allen, which we know now is he really is not Bridge Guy. But Liggett knew that Blair, the only witness who was on the bridge at the same time as the man, described someone who did not match Allen and a car that did not match his. He withheld that contradictory evidence while including the portions of the other witness accounts that supported his conclusion. Wilson's description of the car at the CPS lot as a purple PT Cruiser or small SUV type vehicle is more consistent with Allen's black hatchback than Blair's description of a car that is not black with sharp angles and a 1950s classic old car. The selectivity was not neutral, so they're saying he's doing this on purpose. And even if, and that thing that I didn't understand before, basically, I get it now, is stating that even if he didn't do it intentionally, you have to kind of take it as intentional because it is, at this point, he's like the truth contradicts him. So the selectivity was not neutral. Liggett, I don't know why I pronounced it that way. Liggett included every description pointing towards Allen while suppressing those excluding him. Had Blair described someone who looked like Allen or his car, there is no doubt her description would be front and center to the affidavit. That's true. So if she had said something that was consistent with the state's theory, they would have been sure to put that in their search warrant. The state contends Blair's descriptions are immaterial because the timeline is so tight that Allen had to be bridge guy, regardless of Blair's account. But the argument assumes its own conclusion. The tight timeline holds together only if Blair's account is set aside. We have a second footnote here. The state argued the omission of Blair's descriptions was justified, not a mistake due to a misunderstanding or a slight mischaracterization. Why would her description be justified when she's got conflicting descriptions? The fact that the only eyewitness who definitely saw the man on the bridge described him and the nearby car in ways inconsistent with Allen and his vehicle is precisely the type of information a neutral magistrate would want to know before issuing a search warrant for someone's home. That was a long sentence, I had to breathe. Without the falsehoods and with the omission restored, probable cause evaporates. The state's probable cause theory rested on three pillars: right place, right time, right clothes. The clothing connection. The clothing pillar falls apart. Liggett tied Allen to Bridge Guy through clothing 11 times in the 4-page affidavit, twice falsely representing that Allen admitted wearing matching attire. In reality, Allen said that he did not know what he was wearing that day. He could have worn a blue or black jacket, but also a hoodie or a sweatshirt. So he said he didn't know what he was wearing, but maybe a jacket or a sweatshirt. The blue or black jacket was the glue holding the state's timeline together. Strip away the false claim that Allen admitted wearing it, and the clothing connection dissolves. The timeline. Blair's omitted descriptions of both the man on the bridge and the vehicle in the CPS lot directly contradicts the state's timeline theory. That's another reason why they don't use her, because it just debunks their timeline. Even the state acknowledges that the discrepancies between Blair's description and Allen's appearance might be significant to the extent of probable cause. Yet the state offers no reasoned basis for setting Blair aside. Blair is not peripheral or unreliable. She's been consistent the whole time, unlike other people who have given statements. She is the only person who unquestionably saw the man on the bridge, and the ISP itself validated her account and sketch in a 2019 press release. Liggett hid that validation from the judge. Remember the 2017 press release first came out, they eventually gave a photo, then it became that video, but it's really just like a loop of someone walking on the bridge. That was Bridge Guy video, and they did the audio. They released all those things in the early onset of the investigation. Then later they come out with yet another police sketch. I believe that was in 2019, which is the younger kid with the poofy hair. Allen also never placed himself on the bridge at the same approximate time that Blair saw Bridge Guy there. 2 days after the murders, Allen told investigators he was at the trails from approximately 1:30 to 3:30 p.m. 5 years later, he said it was around noon to 1:30. Similarly, the Harvest Store video shows a car whose license plate and driver are both unidentifiable. Even if the car were Allen's, Blair's testimony that the car in the CPS lot was not black and had sharp angles suggests that Allen was more likely departing via the farmer's entrance, consistent with the 2017 statement to Doolin that he parked at the old farm bureau building. Stripped of the falsehoods and supplemented with the omissions that remains is this. Allen took a walk on the trail in the early to mid-afternoon on the day of the murders and owned a jacket that could have been black or blue. That is not probable cause. This is really well written. I could only say it well. This case is nothing like Ware versus State, involving law enforcement who omitted an earlier eyewitness identification after excluding that alternative suspect through forensics. They had independent evidence supporting the warrant despite the omission. Here, there was no independent evidence linking Allen to the crime. Not one tip or witness identified Allen. As the Indiana Supreme Court has recognized, a neutral and detached magistrate, not a police officer, mistakes the determination of probable cause because officers are engaged in the often competitive enterprise of ferreting out the crime. Law enforcement cannot simply omit information that casts doubt on probable cause. He should have included everything in his request for a search warrant, and then the judge could decide whether it was warranted or not. The appropriate remedy for improper denial of a Franks hearing is reversible and remand. We missed a footnote. Okay, it was all the way up there. So that footnote says, although Allen did not believe he parked at the farmer's entrance, he was far from certain and trying to reconstruct his memory. Sorry. All right. So the appropriate remedy for improper denial of Frank's hearing is reversal and remand, meaning it should be remanded back to state court. So the state erroneously argues that there is no remedy for or harm caused by the trial court's failure to hold a Franks hearing. Courts have consistently reversed and remanded for a Franks hearing. And the state's own argument demonstrates harm. The state contends Allen failed to prove by a preponderance that Liggett's omission and falsehoods were intentional or reckless. But that is precisely the showing a Frank's hearing is designed to allow a defendant to make in person through confrontation with full evidentiary development. So the state is saying Allen failed to prove that Liggett's omissions were false or were done with reckless, intentional, with malice. But they weren't able to contend or contest, rather, his Liggett's omissions because they didn't have that in-person hearing. So the state argues, well, you didn't get to prove Liggett's omissions were false. Well, that's exactly the point. They should have been able to. They should have been able to confront him with evidence, his own words, things like that. The state cannot simultaneously argue that Allen fell short of his evidentiary burden and that he was not entitled to the very proceeding where that burden is tested. A defendant is not required to make two proffers, one to secure a Franks hearing and another to demonstrate what he would have proven at the hearing. Franks and its progeny require no such thing. The ruling for the state would nullify the constitutional protection Franks established. Allen proffered statements from Blair, Carbow, Allen, and his wife, and identified specifically how each contradicted the warrant affidavit. That proffer, at minimum, called the warrant's validity into serious question and entitled Allen to a hearing. Allowing the state's procedural argument to prevail would mean that any defendant whose Franks challenge is improperly denied before trial has no meaningful remedy after conviction. The trial court erred by admitting Allen's confessions. The state's brief answers a case Allen is not making. It portrays this appeal as a challenge to every statement made by anyone in solitary, reframes 13 months of pretrial maximum security solitary as ordinary disciplinary segregation, and treats Allen's decomposition as incidental to rather than the direct cause of his confessions. That framing cannot be reconciled with the record. Allen entered IDOC with pre-existing major depressive disorder, and was placed on day 1 in the most restrictive strip cell on the most restrictive unit of a maximum security prison. For more than a year, he was recorded, caged, and chained on every movement. He lost 40 pounds. He hit his head on his cell door until he had 2 black eyes. He ate his own feces. He was tased and involuntarily medicated with Halidol on 4 occasions, which also, incidentally, those shots last like a month. So that's why it was only 4. There would have been more if it was like, a one and done. That means for 4 months, he was under a hallucinogenic psychotropic drug. Not by his choice. It was involuntary. They just gave it to him. He was found very psychotic and formally declared gravely disabled. Meanwhile, the prosecutor waited 9 days to respond to an emergency transfer motion, mocked the defense concerns as colorful and dramatic, on the same day that IDOC found Allen gravely disabled. Wow. And used the delay to monitor real-time phone calls and collect medical records. So they took 9 days to respond to an emergency transfer motion, called the defense's concerns for Allen's mental health colorful and dramatic, yet at the same time, the IDOC had just found him gravely disabled and used that to monitor all of his calls, medical records, everything. They used it as like ammo to get more information. Ultimately, the state reviewed thousands of hours of cell phone and dispatched an ISP psychologist to consult with Dr. Walla. That is not passive receipt of volunteered statements. That is active cultivation of a pipeline of confessions from a man the state knew was losing his mind. That is a great sentence. That is not passive receipt of volunteered statements. That is active cultivation of a pipeline of confessions from a man the state knew was losing his mind. The question on appeal is straightforward. May the state benefit from confessions obtained under these conditions? The answer remains no. The appellate issue is preserved because the trial court made that clear during trial. Under Rule 103B, once a court rules definitively on the record, a party need not renew an objection to preserve error for appeal. Immediately before the state called its first DOC witness, Allen's attorney requested a sidebar to discuss the mechanics of the confession evidence and to make my objections now and incorporate everything that I argued in pretrial hearings. During the sidebar, those were quotes. During the sidebar, the following occurred. Mr. Rosie says, so I move to incorporate those legal arguments as well. Court says, okay. Mr. Rosie says, and then that way we're not making any objections. The court says, I appreciate that. So all of those legal arguments and all of his objections from pretrial and up until this point, they're renewing them. They're saying, let's do it here on the sidebar and not every single time something comes up during trial so the jury doesn't have to hear it. The court says, I appreciate that. Mr. Rosie says, okay. The court says, that way, because you've made a great record at all of those hearings, so I think we can, and I'll grant your motion to incorporate all of those. Mr. Rosie says, thanks. The court says, into these proceedings. So his objections are renewed there. Later, counsel renewed the objection to Dr. Walla testimony based on everything that I argued before. The court confirmed it and cautioned we don't have to beat a dead horse. So even she was like, okay, you don't have to tell me you're objecting. I know you object. Move on. By incorporating Allen's arguments and stating the court appreciated Allen's attorneys offering to avoid objecting to each of Allen's statements, the court issued a definitive ruling and acknowledged a continuing objection. Moreover, the court's admonishment to stop beating a dead horse only confirms the earlier ruling that additional objections are unnecessary. So you don't need to continue to object. Allen did not need to renew his objection during testimony. The fact that counsel said no objection to individual exhibits after the court that had thanked him for not objecting and cautioned against redundancy does not constitute waiver. Counsel made no attempt to argue or object at trial. Here, counsel incorporated prior arguments, renewed objections twice, and received express judicial acknowledgement. Moreover, the purpose of the waiver doctrine is not to create a procedural trap. Defendant's failure to object to a final instruction did not constitute waiver where he timely objected to the instruction as a preliminary. And that is exactly what the state's argument creates, a trap. When the court asks, do not object to an exhibit, an objection to the suppression issue would violate his assurance to the court he would not object. If his attorney responds no objection, he waives an argument that he spent days making in a preliminary hearing. The state does not assert that Allen's no objection denied the court the opportunity to address this issue that was significantly litigating. Allen filed a motion to suppress with a memorandum and 18 exhibits, including depositions, cell videos, body cameras, IDOC reports. The state responded in kind. The hearing lasted over 10 hours and into the next day, and court ruled. The purposes of the objection rule were more than met, and Allen would have no strategy for wanting confessions he worked so hard in excluding to be admitted. Courts should not apply waiver with unyielding rigidity when the trial court had been alerted to the issue. The next argument, the trial court erred by refusing to consider the IPAS materials that undermine every argument the state makes. So the IPAS materials are part of the record as a proffer. If the trial court erred by failing to consider them, this court can correct the error by considering it on appeal, reviewing issues raised but not addressed by the trial court de novo. To hold otherwise would deny Allen any remedy for the trial court's failure to consider relevant evidence. The IPAS orders findings that prolonged solitary of SMI inmates causes predictable deterioration with hallucinations, sleep disturbances, memory problems, anxiety, paranoia, depression, eating problems, or self-injury. Supply the causation link the state says is missing, prove IDOC's knowledge of the harm, and refute the state's basic needs were met. Framing. The order finds that the IDOC was deliberately indifferent to the mental health needs of those inmates with SMI, like Allen, by confining them in prolonged solitary. The state's argument that IPAS is irrelevant because the settlement resulting from the order may have expired misses the mark. IDOC knew they had a duty to treat Allen's mental illness by moving him out of solitary because they had been successfully sued. There is no expiration on IDOC's knowledge or the district court's order. I have no idea who was suing them. It wasn't Allen or his wife, who for some reason is not suing Westville. She should. The state's prolonged confinement of Allen's constituted coercion, even under the law the state cites. Coercive state action is not limited to police interaction. The state argues that none of the usual hallmarks of police coercion are present because there was no traditional interrogation. But Colorado versus Connolly holds that coercive police activity is a necessary predicate, not that coercion is limited to the interrogation room. Courts have recognized as much. Townsend versus Sane, exploitation can occur in other ways through administration of a sedative, like Paladol, perhaps. A mental health facility's reward system rendered a juvenile's confessions involuntary without traditional interrogation. So they might have been promised some things for confessing. Townsend versus Henderson, conditions of solitary confinement themselves conveyed the implied threat of further punishment. USA versus Karake, months in solitary by itself sufficed to render confessions involuntary. As law enforcement officers become more responsible and the methods used to extract confessions more sophisticated, the court's duty to enforce federal constitution protections continues. The unprecedented nature of this case does not mean the statements were voluntary. The state failed to cite any case where it was permitted to capitalize off the psychosis they created. The conditions of Allen's confinement were coercive. The state ignores Allen's mental illness when arguing no coercion. There is no doubt that solitary confinement is a hallmark of coercion. So just being in solitary confinement alone is possibly coercive to getting a confession out of someone to get them out of that situation, to get them into a better living situation. So what it does to the mind is not contested science. It is a recognized method of breaking down human will. Solitary can bring a person to the edge of madness, perhaps to madness itself. Recognizing scientific connection between prolonged solitary and negative psychological effects. 11 days of solitary rendered a confession involuntary. Conditions would destroy the willpower of almost any human being. So 11 days of solitary in this particular case rendered the person's confessions involuntary, coerced. And that's only 11 days. Try 13 months. I worry about him, and I wonder how he's doing. I know they transferred him out of Indiana, I think to like Missouri or something, but don't quote me on that. So he's in a different state than his wife, but I guess it's better because he's not in the IDOC anymore. It's not in Indiana. So I don't know. I don't know how he's adjusting there. I worry about how he adjusts to being with the rest of Gen Pop. So the state's contrary cases each involved rational defendants. In Rivera, the defendant had counsel present and not mentally ill. In Giles, the court found the defendant a rational person able to consider his options and make intelligent, rational choices. Here, Allen was smearing feces on himself, speaking to people who weren't there, and being involuntarily medicated on the very days he confessed. In Keandra, the defendant spent 30 days in solitary, 1/13th as long as Allen, and was not mentally ill. These cases, and had his, confession stripped. These cases establish a floor that Allen's case vastly exceeds. The state's slippery slope argument fails because Allen's confinement was unprecedentedly harsh. Allen's confinement was unprecedented. Allen was the only pretrial detainee in maximum security solitary in recent history. Pretrial detainees with SMI are housed in mental health treatment. That's serious or severe. What is SMI? I can't think of it now. But they are detainees with SMI are housed in mental health treatment units, so not where he was. Allen was constantly video monitored even when not threatening to take his own life and when moved out of cell. His companions were at his cell door 24/7 documenting his statements even when he was not threatening to take his own life. Pursuant to IDOC's own policies, any other inmate who deteriorated like Allen would have been moved to the mental health unit. But they kept him there to break him down. They wanted to break him down to get these confessions because it's the only thing they have on him. Allen was kept in solitary 13 times longer than the 30-day limit to which IDOC agreed. Allen's harm was both mental and physical. These are not the predictable consequences of disciplinary segregation. They are the predictable psychological pain of prolonged solitary on an SMI detainee. They are the very effects IDOC's 30-day policy exists to prevent, and they are more severe in medical and psychological damage than the conditions described in Brooks versus Florida and Donnell versus Myers because they lasted not 14 days but 13 months. Allen, I guarantee he's got PTSD from it still. Allen does not argue that every statement by every restricted housing inmate must be suppressed. He argues that these conditions imposed on him with his mental health profile over this duration, while the prosecutor actively cultivated confessions, overbore his will. This is precisely the totality of the circumstance required. State failed to prove that Allen's confessions were voluntary. State applied the wrong test and inverts the burden of proof. So the state frames involuntariness as requiring outrageous or barbaric conditions. Okay. Arizona's formulation is not binding. Connolly asks whether the state engaged in coercive activity. Rogers versus Richmond asks whether the defendant's will was overborne under the totality of the circumstances, a test in which mental illness plays a substantial role. So is their will being overtaken by solitary confinement or by, other coercive things that are going on? Um, Halidol, all the things. The state also impermissibly shifts the burden by characterizing this as a sufficiency matter. The state bears the burden preponderance federally beyond a reasonable doubt under the Indiana Constitution. Voluntariness is a legal question reviewed de novo. Courts must consider even uncontradicted evidence unfavorable to the verdict. So a judge must consider all evidence, not just the evidence that fits the case. Question is whether Allen can prove coercion. The question is not whether Allen can prove coercion. It is whether the state can prove the statements were voluntary. That's a good point. The state should prove that he wasn't hallucinating, or this wasn't coerced, or that Walla wasn't biased and working both sides and in all of the social media platforms talking about the case. Considering the proper test with the proper burden, the state failed to prove Allen's will was not overborne by his confinement. The state argues that the conditions of confinement did not cause the confessions because the conditions did not become more oppressive before the confessions began. Connolly only requires that the state's conduct be casually related to the confession. In Townsend versus Henderson, the conditions did not escalate at the moment of confession, yet the implied threat of further punishment conveyed by solitary itself, Vichy, I don't know that word, something free choice. Moreover, the state's argument ignores the clear connection between the duration of solitary and psychosis established in the IPAS litigation and IDOC policies limiting confinement of SMI inmate to 30 days. Dr. Westcott opined that Allen's psychosis was caused by prolonged solitary acting on his pre-existing illness. Even Dr. Walla, the state's own witness, agreed that it was reasonable to believe that Allen's confinement caused his psychosis. Allen's confessions correspond with his psychosis. The state argument that Allen was mentally stable until April 13, 2023 is belied by the record. So they're saying, like, oh, he was fine up until, he just started confessing out of nowhere. In March, Allen told Dr. Walla he was struggling mentally. By March 30th, he was paranoid and evasive. By April 4th, Dr. Walla described his mental health as extremely poor, critical, and deteriorating. By April 12th, he was eating his feces and banging his head on the walls. Allen's attorney also noted his steep decline beginning March 24th, 2023. In their emergency motion, they included photographs taken before he was arrested and on April 3rd, the day he started confessing. So isn't that funny that April 3rd he started confessing when he was already telling Dr. Walla that he was suffering, that he was struggling mentally. Allen's attorney also noted the steep decline beginning March 24th, 2023. In their emergency motion, they included photographs taken before he was arrested and on April 3rd, the day he started confessing. Two very different images. Also, at 3:12 a.m. on the same day, April 3rd, Allen called his father. I don't know how much longer I am going to be lucid, he said. He described being mentally tortured for the last 6 months and feared he was being poisoned a few hours later. Allen called confessing to his wife. His first words were not, I did it, but I think I did it. And yet, in the third call that morning, he could not remember confessing and was afraid he was losing his mind. So, April 3rd, he calls his dad, tells him, I don't know how much I'm going to be lucid for, I don't know how long, and I'm being mentally tortured. And then later, he calls his wife, says, I think I did it. Then in a third call, doesn't remember those other two calls, says he's losing his mind. He later claimed to have shot the victims, a claim contradicted by the medical evidence. A false memory begins with a belief, and that prolonged isolation is a known cause of such beliefs. So being in isolation for that long, you can come up with beliefs. You could believe that you actually really did it. You could have false memories of you actually doing it. So, likewise, Allen's psychosis did not magically end on May 3rd, right before he gives the most detailed confession to Dr. Walla. He was involuntarily injected with Halidol 3 times in May and June. Walla admitting if somebody was just faking something, you wouldn't need to tranquilize them to get them to stop. On June 11th, he believed he was in hell. On June 20th, he was catatonic. Allen's statements expressing guilt correspond with his psychosis, a time he does not even remember. The state cites one exception that in February 2024, Allen apologized for killing the girls. However, he was curled in a fetal position, talking to himself, still in an anti-psych medication, and fluctuating between calm and hysterical. It takes time to heal from the damage the solitary confinement caused. So he's still probably healing. I guarantee he's got PTSD from this whole situation. After 5.5 months of solitary, Allen lost touch with reality, questioning not only whether he was innocent or guilty, but whether he was dead or alive. State's alternative cause theories are speculation. The state's theories that Allen's discovery and religious conversion, independently caused his confessions are speculative and are no different than arguing that a person who confessed after being beaten might have confessed anyway because he was guilty. Dr. Walla admitted that Allen's decline started before his receipt of discovery and that she had never seen Allen's discovery, despite hypothesizing in a clinical note that it probably triggered his breakdown. So she even said in a note that his solitary confinement triggered his breakdown. So she's seeing him in real time break down, and she's writing notes about it, but on the outside she's saying, nope, he's totally good and we're just getting confessions from him. No big deal. Nothing to see here. Even if discovery continued to Allen's decomposition, it does not sever the state's casual contribution. A pretrial detainee does not respond to receiving legal papers by eating feces, ripping mail, and writing a confession under a cell door. Allen responded that way because 13 months of solitary had stripped him of all reserve. If anything, the discovery provided a basis for his delusions. Allen's state Allen's state constitutional claim is meritorious. So Allen stands on his appellant brief regarding the other Indiana constitutional claims. Although the due course of law provision has been applied on in the civil cases, Allen's case is unique. Allen was not seeking due course of law for the deprivation of liberty. He was seeking a hearing for the injuries from IDOC's pretrial solitary, also the second provision of criminal case. When considered with Article 1, Section 15, there must be some due balance to protect against unnecessary rigor when arrested and confined in jail. All right, so the state contends that Article 1, Section 14 requires the same coercive state action predicate as federal due process by pressing the very argument that the Court of Appeals already rejected in State versus Barnes, rejecting state's reading of Ajabu versus State. In Banks, police interviewed a heavily medicated, mentally ill detainee who later did not even remember confessing. Here, police collected confessions of a heavily medicated, mentally ill Allen, who later did not even remember confessing. Just as law enforcement caused Banks' confession by interviewing him when they should not have, the state here caused Allen's cautions through prolonged solitary confinement. Allen's confessions were not a product of a rational intellect, but rather a psychosis caused by the state's indifference to his mental health. The state also argues Indiana's distinctive heightened burden of beyond a reasonable doubt. Even if coercive state action were required, keeping Allen in maximum security prison past the predictable onset of psychosis, declining transfer against his own policy, monitoring and collecting his treatments, opposing his transfer motion establishes it. The error was not harmless. At trial, the state called 12 witnesses and introduced 17 exhibits involving over 30 confessions. During closing, the prosecutor walked the jury through 18 of those and twice replayed Allen's phone calls. In rebuttal, the prosecutor argued that Allen knew a fact only the killer would know. Sorry, I don't know where I got serial. The state's argument is that the confessions were harmless not to survive scrutiny. The trial court denied Allen his right to present a complete defense to explain the scene and impeach the investigation. A criminal defendant has a federal and state constitutional right to present a complete defense. Evidentiary rules that include critical defense evidence on grounds disconnected from the rule's purpose violate that right. The trial court's ruling on 7 categories of defense evidence violated that right and require reversal. So the trial court's rulings on 7 categories of defense evidence violated that right and required reversal, and the state's contrary arguments are unpersuasive. So in this particular case, they sided with the people trying to preserve the land. The trial court committed reversible error by excluding Blair's sketch of Bridge Guy. No eyewitness identified Allen as Bridge Guy at trial. To prove Allen was Bridge Guy, the state rested in case rested its case on a compressed timeline where every witness needed to have seen the same person. Blair did not see Allen. Her sketch proves it. So basically, the state brought up all these different witnesses, and every single one of them says, yes, I saw Bridge Guy. Not one of them says Bridge Guy is that man right there, Richard Allen. Every single one of these people said they saw Bridge Guy, but every single one has different descriptions, and not all of them actually saw Bridge Guy. Blair saw like a young guy with the younger guy with the poofy hair, Betsy Blair. The issue is preserved. The state argues waiver because Allen made no offer of proof at trial. That argument rests on abrogated coleslaw. I don't know. Oh, case law. I said coleslaw. Abrogated coleslaw or case law. Either one doesn't really matter. The argument rests on coleslaw. And has provided that once I'm tired. When I read long documents, my brain gets tired. So the evidence rule since 2014, evidence rule 103B has provided that once a court rules definitively on the record, a party need not renew an objection or make an offer of proof to preserve error for appeal. So they don't need to, like I said, keep renewing their objections. This is what occurred here. The court held a hearing where the parties argued extensively whether Blair's sketch was admissible and issued a definitive written ruling prohibiting the defense from using the composite sketches in the trial of this cause. So they had a pretrial hearing, argued that the sketches should come in because the jury should know that the state was looking at two different people, two different times, but she didn't allow it. So they didn't get to show him poofy-haired boy. The sketch was relevant and not unfairly prejudicial. The state argues the sketch was irrelevant because Blair never identified Allen as Bridge Guy. The state has the logic backwards. The sketch is relevant precisely because it proves Blair never saw Allen at all. She saw this man, young poofy-haired boy or man. Just 3 days after the murders, Blair described the man she saw on the bridge platform as white, approximately 20 years old, medium build, with brown, curly hair. At the time of the murders, Allen was 44 years old, with closely cropped hair he had kept since 1989. A sketch can serve as substantive evidence of innocence to prove someone else committed the crime. Blair's sketch does exactly that. The state claims the sketch was unfairly prejudicial because the jury might use it to exclude Allen as Bridge Guy. That is not unfair prejudice. That is the sketch's probative value. Prejudice is not unfair simply because it undermines a party's theory of a case. The state may, so just because the they're saying that it's unfair prejudice, that it's prejudicial. They're saying the estate argued it's prejudicial to show the jury that there's this other sketch, but that's not actually the case. It's prejudicial to not show them the sketch because you're not giving them the full information. The state made Blair a cornerstone of its identification theory, telling the jury in closing that every witness is adamant the person they saw was Bridge Guy with no doubts in their minds, and that Allen was on the bridge, exactly where Blair saw Bridge Guy. Having built its case on Blair's observations, the state cannot simultaneously claim that what Blair observed captured in a sketch she rated 10 out of 10 for accuracy and declare the reliable face of Bridge Guy until Allen's arrest was too unreliable for the jury to see. State also argues the sketch was cumulative because Allen elicited Blair's verbal description on cross-examination. Are you kidding? She said it was cumulative. All I don't know how to say that. Syllogism is not a story. Blair's description, broken into fragments by questions from lawyers, is no substitute for the sketch's persuasive force. Because if you look at the sketch and you look at Alan, you're going to go, "Oh, that's not the defendant." Only by viewing the complete image, the full face Blair drew 3 days after the murders, could the jury appreciate Alan's claim of innocence. The persuasive power of the concrete and particular is often essential to the capacity of jurors to satisfy the obligations that the law places on them. Moreover, the sketch carried probative force beyond the identification question. For 2 years, law enforcement circulated Carbau's sketch without an arrest. In April 2019, ISP released Blair's sketch, declared it the face of Bridge Guy, and announced Blair and Carbau, saying that they had not seen the same person. So ISP themselves, Indiana State Police, have a press conference in 2019 and say, this guy right here is your guy. This is it. The other guy we showed you in 2017, ignore that. This is your guy. That's what they're telling you. After Ellen's arrest, the state reversed course. The sketch placed before the jury alongside that reversal would have told the story of an investigation that changed its theory when it became convenient, a story Blair's verbal testimony alone could never tell. So being able to show that photo would absolutely prove that the state, and being able to tell the jury, look, the state said, first of all, it was this guy, which obviously then they changed in 2019 and said, now it's this guy. So which is it? They can't both be the guy unless there's multiple guys. That's another reason to have the sketches shown, is that it could be to multiple people that committed the crimes. Which was another theory that the state was on, and then they changed it as soon as they arrested Allen. So all of that stuff should have come in so that they could question the investigation, the legitimacy of the investigation. The sketch was not hearsay, and if it was admissible. A composite sketch is a visual depiction, not a statement, within the meaning of Rule 801A. It depicts rather than asserts. When courts across the country have encountered this question, they agree. That's the citation. The state does not dispute this and confines itself to arguing waiver, but as shown above, the issue was preserved. So the state's just saying, well, we don't dispute it, but you waived your right to do anything to it because you didn't object, which, as we know, is not necessary. Even if treated as a statement, the sketch is admissible on 2 independent grounds. First, Rule 801 excludes from hearsay a prior identification of a person made after perceiving that person where the declarant testifies and is subject to cross-examination. The rule applies to identifications of a person, and the drafters did not limit it to the identifications of the defendant. So you can identify any person. It doesn't have to be the defendant. It could be another suspect. The state offers no authority to the contrary. Second, the sketch is an adoptive admission under Rule 801. The state, through the ISP, manifested adoption when it publicly released Blair's sketch in April 2019, declared it the face of Bridge Guy, and announced Blair and Carbau saw different men. The state cannot formally adopt the sketch as authoritative before Allen's arrest and then bar it as bar its use at trial. So it can't just say, this is the definitive photo that is your guy. You need to look at this and see this because we're saying this is your guy. And then all of a sudden trials here, you've got a different guy that looks completely different and you hide that. You try to bury those pictures that don't look anything like Richard Allen. It's not a good look for the state. The trial court committed reversible error when it excluded Perlmutter's exculpatory explanation of Bridge Guy's murder scene. So, Perlmutter was supposed to, I believe, talk about the ritualistic aspects of the crime, the Odin aspect, the runes, all of that. He was supposed to testify to that, or she. I think it's a she, but was not able to because, she was not able to because of Judge Gull saying, no, you don't get to defend yourself, pretty much. So Perlmutter holds a federal subject matter expert designation from the United States government in ritualistic crime and has consulted with the FBI, DEA, and Department of Homeland Security. She directs the Symbol Intelligence Group, is an adjunct in the forensic medicine program at the Philadelphia College of Osteopathic Medicine, and has authored textbooks on ritualistic homicide. She has worked on dozens of ritual homicide cases and hundreds of ritualistic crimes, primarily for prosecution. The state does not now argue that she was unqualified. Its argument is exclusion under Rule 403. The foundation for Perlmutter's testimony was not speculative. It was the state's own investigation. The cases the state relies upon, Pelly, Lashbrook, and their progeny, share a common premise. A defendant approaching the court with an alternative theory the prosecution never considered, supported only by the defendant's own speculation. Hearsay statements about a Florida bank connection with no investigative support, a single ambiguous statement that the victim was going to die, the concern in animating those cases, jury confusion from unmoored alternative theories is absent here. The ritual killing theory was not Allen's invention. So that's the difference between these cases and Allen's case. So the cases that the state is citing or relying upon for case law doesn't compute. It's not the same. They're citing cases in which the defendant came up with their own scenario, their own speculative third party, theory, a theory of a third party suspects. But in this case, Allen didn't invent the Odin ritualistic killing theory. It came directly from law enforcement. It was law enforcement's own theory, developed from the first day at the scene, pursued for years, and supported by multiple independent sources. The foundation for Perlmutter's testimony is not a defense attorney's theory. It is 5 years of law enforcement investigation, FBI consultation, and academic analysis, all pointing in the same direction. What changed was not the evidence. What changed was the arrest. When Allen was charged, the state abandoned the theory, reversed its position on the Blair and Carbough sketches, recharacterized the investigation as complete, and moved to exclude the evidence it had spent years developing. That reversal is not a neutral evidentiary decision. It is confirmation bias made visible. Law enforcement finding a more convenient suspect and retrofitting the evidence to fit him, discarding what pointed elsewhere. The jury was entitled to see that pivot. The trial court's rulings ensured it never did. Well written. So basically, law enforcement got their suspect. They were heading down a total different path. Then they got a convenient suspect that they could pin it on. And then only the information that fits their case is now what they're presenting, when all this other stuff that the defense didn't get to touch, even though they got to see it in discovery, most of it, even though it took a long time for them to get all the discovery, they see the defense looks at all the evidence and they're like, oh, wait a minute. The investigation was multiple people, ritualistic in nature, some kind of sacrifice, right? There were runes on the scene that may or may not have been symbols for something. And that was all part of law enforcement's original investigation. All of a sudden, they just want that buried and they don't want the jury to hear any of that. Well, that's not how it works. I'm sorry, but no. The defendant has a legal, and actually the attorneys have a legal obligation, the defendant has a legal right to defend and to be able to provide alternate theories, be able to provide those third party suspects that law enforcement originally were honing in on, right? But to just say, oh, none of that information ever even existed, we're just going to pretend that it's just nothing. It's not there. All that evidence, all the stuff that Perlmutter could have testified to regarding ritualistic sacrifice, none of it can't come in. So Dr. Perlmutter was excluded from testifying. The asymmetry doctrine required Perlmutter's admission and the state fails to engage with it. The state called expert witnesses to interpret the crime scene's unusual features in an inculpatory direction. Allen was denied an expert to interpret the same features in an exculpatory direction. Indiana law has long held that the state may not use evidentiary rules as both a sword and a shield, presenting its version of contested evidence to the jury while blocking the defense from offering a contrary explanation for the same facts. The murder scene demanded an explanation that the state's theory could not provide. Exactly. Sticks were deliberately arranged on both girls' bodies in configurations that covered no more than 3% of their surfaces, far too little to conceal anything, serving no practical purpose a brutal, opportunistic murder would require. Libby's 200-pound body was dragged several yards after death and positioned in a V formation. The girls were treated differently from each other in ways that suggest intentionality rather than impulse. The scene, taken as a whole, reflected a purposefulness, a deliberate, almost ceremonial quality that the state never explained, and that sits uneasily beside its theory of a middle-aged pharmacy technician with no connection to the victims, no motive, and no history of violence committing a spontaneous public murder before walking home. The state argues that Perlmutter's evidence was irrelevant because motive was not a significant factor in the proof of guilt. Allen never claimed motive was important to the state's case, but motive was critical to Allen's claim of innocence because the scene suggests a motive inconsistent with Allen's guilt. The trial court wrongly excluded a map that indicated an alternate murder plan inconsistent with the murder plan the defendant could have been involved in. So that's another case, not this case. A court cannot prohibit a defendant from offering evidence of an alternative motive because the state failed to present evidence of the defendant's motive. Although the state can open the door to otherwise irrelevant evidence, it cannot close the door to otherwise relevant evidence. Any challenges to the weight of Perlmutter's testimony are arguments for cross-examination, not grounds for exclusion. So she shouldn't have been excluded. She should have been able to give her testimony and be cross-examined. Trial court denied Allen his right to show the state's investigation into Bridge Guy's identity was incomplete, overlooked plausible leads, and mishandled evidence. The state claims Allen failed to establish a nexus between the third-party evidence and the crime. The record refutes that claim across 5 independent connections. The nexus to the victim. The goddamn nexus that she kept saying there was no nexus. There was no nexus. There was a nexus the size of Texas, but she didn't want to see it. The nexus to the victim of the Odinist stuff, not Richard Allen. Richard Allen had no ties to the victims. So the nexus to the victim. Abby Williams was secretly meeting with Logan Holder, the son of Brad Holder, the leader of the pagan group conducting rituals in Delphi every weekend. So Brad Holder, leader of pagan group, conducting rituals in Delphi every weekend. This particular murder seems to have some ritualistic aspects to it, and Abby was dating the son of this guy who does these ritualistic ceremonies. But there's no nexus, guys. Judge Gull says there's no nexus, so there's no nexus. That is a direct personal connection between a named suspect and one of the murdered girls, established through law enforcement's own investigation, not the defense's speculation. And that connection became more significant, not less, as Holder's account of his relationship with Abby Williams evolved 3 times over 7 years. The nexus to the crime scene. Holder had a bind rune tattoo that was nearly identical to the stick arrangement on Abby Williams' body. Before those details were public, Holder was posting pictures depicting dead girls with sticks placed on their bodies. Westfall told law enforcement he knew the woods near the murder scene very well. Patrick Westfall, who was also in that group. The nexus to the murder weapon's caliber. Brad Holder himself owned a .40 caliber Smith & Wesson, the same caliber as the cartridge found between the bodies. Law enforcement never collected it or tested it. The state's firearms case rests on the proposition that only Allen's gun could have produced the scene cartridge, a proposition meaningfully undermined by the existence of an uncollected .40 caliber firearm. You can't say it could have only come from Allen's gun when you didn't try Holder's gun, when Holder could have also been there. There's more of a nexus to Holder than Allen. The nexus through law enforcement's own conclusions. The Carroll County Sheriff connected the sticks to pagan rituals immediately. Multiple officers concluded the scene was too complex for one person. The FBI BAU declined to exclude ritual killing. So the FBI did not exclude that it was ritualistic in nature. A Purdue professor confirmed the stick markings were consistent with Norse runic symbolism, or similar to Odinism, Norse whatever. These are the state's own pre-arrest conclusions, a nexus that law enforcement itself found compelling enough to pursue cannot be dismissed as insufficient when the defendant adopts it. So it was the defendant's, or I'm sorry, it's not the defendant's theory, it's the state's theory that he's only trying to argue to put forth as an alternate theory, yet he was barred from doing so, which is not how the system is supposed to work. Next, the nexus through Holder's own admissions. Holder told his wife that Patrick killed Abby Williams with others and warned her that if I talk, that they would kill me. The statement is admissible as circumstantial evidence of Holder's own consciousness of guilt. A person without guilty knowledge has no reason to threaten his wife into silence about a crime he sincerely believes someone else committed. And the statement itself is joiner nexus evidence, a named alternative suspect identifying another named alternative suspect as the killer makes it less probable than Allen committed the crime. The state's nexus, argued effectively, requires forensic placement at the scene, DNA or physical evidence directly linking Holder or Westfall to the murders. That is not the joiner standard. So the state was arguing you need to have some kind of DNA or physical evidence that these people were there. That's not the standard. She totally was wrong on that. Joiner required reversal based on motive, opportunity, conduct, and a forensic hair match. Allen's evidence, victim connection, crime scene imagery, same caliber firearm, direct familiarity with the murder location, law enforcement's own pre-arrest conclusions, and Holder's post hoc admission is a stronger multi-factor package than what Joiner found sufficient. Lashbrook distinguished Joiner on its facts. It did not establish DNA as a universal prerequisite for third-party evidence in every case. The state's claim that police investigated and never connected Holder and Westfall to the crimes is not a response to Allen's argument. It is a restatement of the problem. The right to challenge the investigation. So basically, the state or it says the state. So basically, the state is saying, well, Holder and Westfall were never connected to the crimes. They were never investigated for these crimes, really. So that's kind of the point. They have a right to challenge the investigation's thoroughness. Why weren't they looked into as suspects? Cancel. They should have been looked at as suspects. The right to challenge the investigation's thoroughness would be meaningless if the investigation's own conclusions could insulate it from challenge. Cleared in this investigation did not mean investigators looked and found nothing. It meant they accepted an unverified badge swipe without watching the surveillance video, never tested Holder's .40 caliber against the scene. So they never tested his badge card or whatever when he swiped out of work, or the surveillance video. They never tested his caliber. They never examined Holder's phone. They allowed Patrick Westfall, to delete his phone data before ever turning it over, and they ignored Trooper Winter's recommendation that Holder be re-interviewed after finding Holder's social media posts depicting young girls believed to be deceased with sticks placed on their bodies, and took 6 years to examine Westfall's alibi, only to find it could not be confirmed. So Westfall's alibi took him 6 years and not confirmed. Not a good alibi. So a jury that understood those facts would have evaluated the state's cleared conclusion very differently. Right? So those facts should have come in. That is precisely why the evidence should have been admitted and precisely why its exclusion was not harmless. The state conflates alibi accepted with alibi confirmed. Those are not the same thing, and the record makes the difference plain. The badge swipe occurred outside Holder's usual shift schedule. The badge was on a public rack accessible to any coworker, with no way to detect whether Holder had swiped it himself. He could have had someone swipe it for him for an alibi. The HR officer said so directly. Investigators declined to watch the surveillance video that would have resolved the problem. So investigators were like, oh, there's a video? Nah, we don't need that. We believe it was him. It's okay. This is so bad. They had to have known. I think investigators know that it's Holder and Westfall, and they're protecting them for some reason. Westfall's alibi, accepted for 6 years without examination, could not be confirmed when it was finally tested. These are not the hallmarks of a confirmed alibi. They are the hallmarks of a flawed investigation. Joyner did not require the defense to disprove a third party's alibi before the evidence became admissible. It required only that the evidence tend to make it less probable that the defendant committed the crime. The Holder-Westfall ritual killing evidence does that, and the state's mishandled alibi investigation only serves to make the evidence more probative. This is wild. We are learning things in this that I didn't know about some of this stuff, how it was being done behind the scenes. The court committed reversible error in excluding Tobin's testimony. The state argues Tobin was an unqualified expert in one field. The state argues Tobin was unqualified because an expert in one field cannot offer opinions in another absent a showing of competency in that field. I don't get that. Okay, but Prewitt is in opposite. Tobin was not asked to perform a firearms examination or opine in a field outside his expertise. He was proffered to explain the scientific community's critique of AFTA or AFTE's methodology, a subject squarely within his expertise in forensic metallurgy, material science, statistics, and 24 years managing forensic metallurgy operations at the FBI laboratory. As a fallback position, the state claims that Tobin's testimony went to admissibility, which is for the court rather than the jury to decide. This argument is contrary to law. Trial courts determine whether expert testimony is reliable and thus admissible under Rule 702. But once admitted, the jury decides whether the expert's credibility and the weight to give her testimony. Here, Tobin's testimony served both purposes. It went to the reliability and admissibility of firearms identification evidence and the credibility and weight the jury should give Oberg's conclusions, which were based upon the AFTA methodology. Allen moved to exclude Oberg under 702, and the trial court denied the motion without hearing. Allen then proffered Tobin to attack the weight and credibility of her opinion before the jury. The jury should have heard from Tobin, so this is another expert witness that was excluded. Excluding Tobin's testimony, citing firearm identification methodology reversible error testimony was question of fact for jury. So the fact that Tobin was denied to Allen was denied to have Tobin's testimony to really explain Oberg what was wrong with Oberg's testing and why it was unreliable. That was absolutely important and should have been able to come in. And it's up to the jury. It should be a battle of the experts. It shouldn't be the state says, no, I don't like your expert, so I don't want your expert to testify because it hurts my case. That's not how it's supposed to be, but that's what happened here. Finally, the state argues harmless error because Allen had alternatives to impeach Oberg, but by excluding Tobin, the court stripped Allen of his chosen defense that AFTA methodology is not credible science and locked him into a narrower one that necessarily conceded the validity of the only physical evidence against him. Allen's fallback witness, Eric Warren, is an active AFTA board member who endorses the methodology. The jury heard a debate about whether Oberg applied AFTA correctly, not whether AFTA is credible. So that's the difference. So Dr. Warren testified. He was their gun expert, but he's there's a lot of controversy in the community of whether AFTA methodology is appropriate or not, whether it's reliable science or not. And Dr. Warren just happens to lie on the side that it is reliable, so he didn't go into the whole explanation as to how it can be unreliable. And that's what the jury didn't hear. So that's a big distinction there. This forced substitution of Allen's chosen defense for another is not harmless and affected his constitutional right to present a defense. The court committed reversible error by excluding evidence impeaching the credibility of Allen's confessions. The solitary confinement video audio. The state argues that Allen's statements in the solitary videos are hearsay because they do not facially pertain to his state of mind and that the guard's statements were also hearsay. This court should reject both arguments. Allen offered the videos to show he was screaming, speaking incoherently, quoting scripture, singing, and making delirious statements about being King Michael, being cryogenically frozen, and starting World War III. There is no hearsay problem when a statement is offered to prove the fact of the utterance rather than the truth of the facts asserted. Similarly, Allen proffered the staff audio to show how prison staff talked callously to him despite his obvious delirium. A statement is not hearsay when offered to show the effect on the listener. There you have it. The state next invokes Sweeney versus State, claiming the audio was a self-serving attempt to enhance Allen's credibility. The state has it backwards. Sweeney concerned a defendant using prior consistent statements to bolster his own testimony. Allen was doing the opposite, using his own words to show he was delusional and undermine his solitary confinement statements. The state's fallback argument that Allen had adequate other means to impeach Dr. Walla and that psychosis is fluid ignores what the audio shows. The argument is not simply that Allen was psychotic on some days. The argument is that the jury needed to see and hear the specific man the state's own doctors were describing as more organized than he'd been on May 3rd, and to place that clinical characterization along the April 28th video of Allen covered in feces, asking to be euthanized, claiming to be King Michael, and singing hymns. Words matter. Without audio, the jury watched a silent film. Without it, the jury would have experienced the full scope of Allen's psychosis. The state told the jury Allen was more organized the week before his confession, but the jury never heard what more organized actually meant, nor did they get to hear it. April 3rd, phone calls. The state played one of the 3 calls Allen made on the morning of April 3rd, 2023, a 5:14 a.m. confession call, and then used Trooper Harshman to characterize Allen as calm, subdued, and solemn when confessing, showing no indication of duress or stress. The 2 calls that bookend the confession demolished that characterization. They should have been admitted under the rule of completeness. The state argues the trial court permissibly excluded the bookend calls, citing Liberance versus State, Trans denied, and Hawkins versus State. Those cases support Allen, not the state. Liberance provides that Rule 106 may be invoked to 1. Explain the admitted portion, 2. Place it in context, 3. Avoid misleading the trier of fact, or 4. Ensure a fair and impartial understanding of the admitted portion. Hawkins adds that Rule 106 is limited by fairness, and where calls are distinct and unconnected, fairness does not require their admission. In Hawkins, the defendant sought to introduce other jail calls simply because the state had played some calls with no internal connection to the admitted recordings. The court found no fairness basis to require their admission. In Liberans, the omitted January statement was from a separate interview conducted 2 months before the admitted March statement, and the March statement contained only an oblique reference to the prior statement. This case is the opposite. The 3 April 3rd calls are not distinct conversations. They were interlinking and cross-referencing conversations within a 5.5-hour window. In the 3:12 a.m. call, 2 hours before the confession, Allen told his father he did not know how much longer I'm going to be lucid, and warned he could not vouch for what he was going to say going forward. I don't know what I'm going to say. The admitted confession calls references this call directly, making the 3:12 a.m. call not merely contextual background, but genuinely explanatory of the admitted call's content. In the 8:43 a.m. call, 3 hours after the confession, Allen asked his wife, Did I call you this morning? When she confirmed he had, he said, I had the worst dream last night. He could not remember having confessed. All 4 Liberance factors are satisfied here. Fairness required their admission. Without the bookend calls, the jury only heard a confession with them. The jury would have heard a man who warned his father that he could not vouch for what he was about to say, and who later could not remember confessing. Coercion's foundation testimony. At trial, Dr. Coercion testified that Allen suffered from delirium. When Allen asked Coercion about the observations that formed the basis for his opinion, the trial court prohibited him from answering. That ruling was error. Rule 703 provides that an expert may base an opinion on facts or data the expert has been made aware of or personally observed, and may testify to opinions based on inadmissible evidence, provided that it is the type reasonably relied upon by experts in the field. Coercion reviewed phone calls, IDOC records, solitary confinement videos, the transcripts of Allen's statements, the type of material a forensic psychiatrist routinely relies upon. Rule 703 entitled him to identify specific observations from that review, including statements Allen made that were objectively false as a clinical foundation for his delirium diagnosis. The state argues Allen waived this issue by failing to present Rule 703 below. The argument fails. A defendant preserves an evidentiary error by making an offer of proof which need not be formal. An attorney's explanation of the evidence sought to be proved is its relevance, and the answer to the objection is sufficient. At sidebar, Allen's counsel explained that Coercion was prepared to testify that his delirium opinion was based on Allen making statements clearly not consistent with the facts and patently false, including the claim that the girls were shot. I just read through this. don't know if it's aired yet or not. I don't think so. But Dr. Coercion, um, you'll hear, or that will be in the upcoming episode, I think next week. And you'll see that he did try to testify about the delirium, and anytime he tried to apply anything to the defendant himself, he was objection, and so and everything got sustained. So every time he tried to apply his knowledge about delirium and Richard Allen's symptoms, and applying it to the defendant, anytime he would say, as I reviewed the defendant, objection. Like, you can only talk about what solitary confinement can do. Hold on. Little puppy playtime. So I forgot what I was saying. Oh, he testified to the effects of long-term solitary confinement, but he couldn't say that I saw those symptoms within Richard Allen. So anytime he would try to say that Richard Allen was suffering from those symptoms, objection. So it couldn't come out. The trial court was plainly appraised that Allen was offering to show the jury the observational basis for Coercion's diagnosis. The issue is preserved. Rule 704B and Kincaid versus State do not apply. As Kincaid explains, Rule 704B prohibits opinions on the truth or falsity of allegations, contested factual claims whose truth the jury must determine. The question here was categorically different. Whether objectively false statements Allen made, for example, statements whose falsity is not in dispute, were among the observations forming the foundation for Coercion's delirium diagnosis. That is not an opinion on the truth or falsity of the confession. It is a clinician identifying the observable symptoms that support a diagnosis. Very well stated. He wasn't able to go into that, saying, like, I saw these signs within Richard Allen from what I viewed. This is precisely the specialized knowledge Rule 702 and Miller versus State say expert testimony exists to provide. Coercion was entitled to answer. Judge Gull said no. The data on Libby's phone is consistent with human interaction at 5:45 p.m. and the state's impermissible rebuttal was harmful error. Stacey Eldridge, a former FBI forensic analyst, found data consistent with a person interacting with Libby's phone at 5:45 p.m. An incoming call arrived milliseconds before a wired headphone cable was inserted into the device, silencing it. The state says the last time her phone was touched was sometime in the afternoon, to something in the afternoon. The state concedes the trial court impermissibly allowed the state's witness to impeach this testimony with Google searches from anonymous troubleshooting forums. This was not scientific, not, actual verifiable scientific proof. He just did a Google search and saw some forums of people talking about, oh, it could just be dirt. Okay. The state resorts to arguing harmless error on two grounds. There was no movement on the phone at 5:45 p.m., and the purported interaction coincided with the height of the search of the girls. Both arguments fail. The phone showed no steps, no movement, and a person can interact with a phone without logging one. The search began sometime after 5 and before the crime scene was located, precisely when someone with access to the phone would want to silence incoming calls. The harmlessness argument also misses the deeper point. The state's theory requires a single killer who committed the murders, left the scene, and was seen by Carbow. Hold on. So the state's theory requires a single killer who committed the murders, left the scene, and was seen by Carbow walking west on 300 North at 3:56 p.m. But if someone was interacting with Libby's phone at 5:45 to silence an incoming call, that person was at or near the scene 2 hours after Carbow's sighting. A single killer cannot have been seen leaving at 3:56 and still been with the phone at 5:45. Eldridge's finding is not a credibility dispute about phone data. It is direct evidence contradicting the state's all witnesses saw the same person timeline. Carbow did not see the killer leaving because the killer had not left yet. Without the internet forum hearsay, the jury would have had Eldridge's findings standing unchallenged, finding that properly understood do not merely undermine the step data but unravel the state's entire timeline. So if she hadn't have been if I can't remember, I think it's Cecil. One of the investigators comes in and says, we Google searched it. It could be dirt or water or something that gets into the port. Okay. Well, was there dirt or water? Did anybody look at it? But they use that as, it's reasonable doubt that it was an error, that the data is in error somehow. Makes no sense, but okay. So the trial court committed reversible error in denying Allen's motion to correct errors. Weber testified he clocked out at 2:02 p.m. and drove 20 to 25 minutes home. The state presented the arithmetic to the jury in closing. Weber got home sometime around 2:30, they said. His van appeared on the private drive at the exact time Richard Allen would have been there with the two girls. And that was something only the killer would know. Weber was not on his private drive before 2:45. His testimony was demonstrably false, and the state knew it. The timeline... He testified to 2:30, but he wasn't there until after 2:45. 14th Amendment is violated when the prosecution knowingly solicits false testimony or knowingly allows it to go uncorrected. The state claims Allen's falsity argument is predicated on an unreliable surveillance video. Not so. It is predicated on the state's own FBI subject information sheet dated March 3, 2017, in the state's possession, which states explicitly Weber's phone pings to parents' address overlooking crime scene initially at 2:50 p.m. The surveillance footage Allen presented in his motion to correct errors merely corroborates what the state already knew. Weber's testimony was false. The state suggests Weber's testimony was not demonstrably false because he never testified to an exact time of arrival. This misreads Nape, this other case that sets the precedent. Weber's testimony was false because he represented he drove directly home, not because he gave a precise arrival time. And the state did not merely fail to correct the misrepresentation, it exploited it. Trooper Harshman corroborated Weber's account step by step, confirming Weber's 2:02 p.m. clock out and testifying that Weber told him in August 2024 that he drove the white van straight home and that this absolutely fell into place with Allen's confession detail. The state converted an imprecise false statement into a precise corroboration of guilt. The state claims Allen waived his NAPU claim. A defendant waives NAPU only if he knew the testimony was false but made no attempt to demonstrate its falsity. Allen made 6 attempts. The state obstructed every one. Allen attempted to impeach Weber with a prior inconsistent statement. The state objected and sustained. Allen attempted to show Weber had a motive to lie as an early suspect or person of interest. The state objected twice. Both sustained. Allen subpoenaed the FBI special agent who prepared the report documenting Weber's inconsistent account. Testimony quashed at state's request. Allen attempted to elicit Weber's prior inconsistent statements through agent Christopher Guti. The state objected, sustained. Allen recalled Weber directly and attempted to impeach again. The state objected, sustained again. It's a strong showing that they try to impeach this. witness. The state solicited false testimony that inculpated Allen, used its own officers to make the testimony sound even more inculpatory, and then actively resisted Allen's attempts to correct the false evidence. This is a blatant NAPU violation. The errors were harmful whether considered individually or collectively. Before law enforcement ever even talked with Allen, they jumped to the conclusion that Allen murdered Abby Williams and Libby German because he told Detective Doolin in 2002 that he saw 3 girls on the Freedom Trail and 4 girls that would be I can't remember their names. Those are the initials of the girls. I can't remember them all. Those 4 girls thought that they saw Bridge Guy on that trail. In Detective Mullen's mind, that means Allen had to be the guy that saw the 4 girls and thus Bridge Guy. But there were many people out there that day. But RV and her friends alleged Bridge Guy's sighting is uncertain evidence. The girls could have been wrong that they saw Bridge Guy, and even if they did see Bridge Guy, it does not follow Allen that has to be that guy. Regardless, law enforcement tunnel vision on Allen when he could not remember where he parked and what he wore 5 years earlier. Law enforcement pushed him to say what they wanted him to say. Across 2 recorded interviews, one before his arrest, one after, Allen consistently and emphatically denied guilt. He insisted he was not Bridge Guy, declared he had never met those girls, twice repeated, "I did not murder 2 little girls," and denied 17 separate times that the casing at the scene from the gun, what did not come from his gun. To get a warrant, they ignored that Betsy Blair, the only eyewitness to the man on the bridge, described someone different than Allen and his car. They ignored that Blair said the man Carbow saw was different than the man that she saw, Carbow and Sarah. And they lied about Allen admitting that he wore a blue jacket. They abandoned the obvious theory that more than one person did it. They ignored the oddness of the scene and the sticks and the fact that Allen lived and worked in a community for 5 years, contacted law enforcement proactively to help, and cooperated fully. 5 days after the murders, Allen gave law enforcement his unique identifying numbers for the phone they now claim he was trying to hide. But he gave them the info. They confined Allen, who had never been arrested, in the most solitary and restrictive cell in Indiana. When Allen predictably deteriorated, the state mocked his attorney's concerns about his health while collecting psychosis-induced confessions. The IDOC and eventually the trial court, at the state's request, ignored the IPAS or the IPAS order and settlement, showing that solitary confinement caused the very mental illness that the state was now exploiting. And at trial, Allen was not permitted to tell his story, or this story, of tunnel vision into the wrong man. The jury never saw the sketch of Bridge Guy that clearly was not Allen. The jury was not permitted to hear about a realistic explanation for the scene that even the state considered prior to Allen. They could not hear about how the state failed to thoroughly investigate paganists with connections to Abbey and bloodletting rituals. Nor could the jury hear that the very science upon which the state was asking them to find that Allen's gun was at the scene was unreliable and untrustworthy. This is especially troubling when the prosecutor argued the state's firearms analyst had never been wrong. What? How did he get to argue that? Did he say that in his closing? That's wild. The jury never got to hear Allen's tangential, pressured, and delusional speech to show his confessions were not reliable, despite the parade of state's witnesses claiming he was lucid or faking. The jury was misled to believe that Allen knew a fact only the killer would know by presenting false evidence that Weber came home at the time that absolutely fell into place with the state's theory of when Allen would have crossed the water with the girls. Allen's conviction is based on a one-sided story. The state was permitted to build a tight timeline based on the 4 girls, Blair and Weber the phone data and Carbow only because Allen was prohibited from impeaching each piece of evidence. If even one of these is wrong, the state's entire timeline unravels. With Allen's hands tied, the state's timeline went from superficial inference stacking to hard facts corroborated by confessions and a firearms match. Had the jury known all the evidence that impeached their timeline, firearms science, and Allen's mind at the time he was in solitary, there is more than a possibility the jury would have acquitted him. The state has failed to prove beyond a reasonable doubt any one error, let alone the cumulative weight of all of them, did not contribute to the verdict. It has been said that a half truth masquerading as a whole truth becomes a complete untruth. The only way our justice system works is if the jury hears the full truth. Because the jury only heard half the story, Allen was denied a fair trial. Conclusion: wherefore the appellant respectfully requests the court to reverse the judgment. And that is the end of that filing. So, yeah, it's going to be interesting. What do you guys think? Well, first of all, they need to be, the Supreme Court needs to determine if they're going to even do oral arguments, if they'll hear them for oral arguments, but it'll be interesting to see what happens. And puppies are playing, so I gotta go. Thank you guys so much for watching. Take care. I'll see you in the next one. Bye, guys. That's our Corruption Files update. Another layer of corruption peeled back. Thanks for watching. Let me know in the comments what stood out and join Justice Insider to get exclusive perks. Catch you in the next one.